had a weapon, they just jump out of a bush at you, Blackstone said you had an immediate right to use lethal force because they could intend you no goodwill. There has never in our society been this duty to retreat where you are an innocent victim. Yet our laws are so complex and so compounded on this right and duty to have to retreat that it's absurd. Many of you probably know that in 2011, Pennsylvania changed our laws in regards to whether or not we had a duty to retreat. And while there are certain occasions where one still does have a duty to retreat in the Commonwealth, generally we now have what we call a stand your ground doctrine, where you do not have to retreat when someone intends you or another person serious bodily harm or death. But they must have a weapon that's capable of inflicting serious bodily harm or death. To Blackstone and Locke, that was not required at all. So we still have very far to come from where we've begun. And it's quite unfortunate. The laws here in Pennsylvania are so complex that I conduct firearms law seminars where we review both the state and federal firearms laws. They generally are 4-hour seminars. When I start the seminar, I tell everyone in the room, I bet you're thinking right now, there is no way possible I could talk for 4 hours straight about the firearms laws in this Commonwealth, and yet we will get to the 4-hour mark, and I still will not be through all the course materials. That's how complex the right to keep and bear arms that shall not be infringed has become. I was actually speaking with an individual earlier tonight who came up to me and said, there's a question that I've never heard an attorney answer. I've never heard anyone actually answer. And that is, pursuant to the Second Amendment, how do we prohibit felons, the mentally ill, and those individuals? And I said, quite honestly, if you read the Second Amendment, and you're a strict constructionist, there is not a way to prohibit those individuals. And many people are taken back by that. But that's what the Constitution provides. If you don't like it, there's an amendment process. Many would probably support that under certain limits and restrictions. But that is why we have that amendment process. It is not for the courts to come in and say that we read shall not infringe to be reasonable restriction is okay. And we have seen this time in and time again. Many of you are probably familiar with the Heller decision, which came out in 2008 by the Supreme Court. It was the first time that the U.S. Supreme Court found that the Second Amendment was an individual right. It's very interesting how attorneys gloss over many of the key aspects of that case. And I want to share one of those key aspects with you tonight. Everyone looks at Heller as saying you have an individual right to keep and bear arms. But, as the court states in the decision, nothing shall cast doubt on the fact that those laws that currently exist prohibiting felons and the mentally ill are lawful. The aspect that I want to draw your attention to is the court took time to define what constitutes keep and bear arms. Does anyone know what the court defined as the right to keep and bear arms? It was actually quite interesting. The court said the right of the person to keep a firearm in his clothing or in his pocket for, in essence, defensive purposes. Let that sink in. The court already held under the Second Amendment that you had a right to keep a firearm concealed on your person. Last I checked, a fundamental right cannot be licensed. Now, being an attorney who's actually argued this issue before the Commonwealth Court. All the judges' heads kind of just spun around when I argued it. It's disconcerting that we do have many on the judiciary who won't look at the exact words that the Supreme Court declared. This is but one of the issues that comes out of Headland. And there are a multitude of other ones. And that's why it is as lengthy as it is. Now, I know on the agenda tonight, we're going to talk about some other issues, some of the pending bills, some of the issues with municipalities that are violating state preemption. And we are. But before we get there, everyone needs to understand that it all starts with the Second Amendment, as well as here in Pennsylvania, Article 1, Section 21 of the Pennsylvania Constitution. In fact, the Commonwealth Court, in a decision, stated while the Second Amendment only recently was acknowledged to be an individual right, here in the Commonwealth, we've never questioned it. That's strong words for the same court that would come out and say that it's acceptable to license the carrying of a firearm for your own protection. Every one of us is responsible for those decisions, because every one of us has the distinct honor and privilege of voting for our judges here in the Commonwealth. Never take that for granted. With many of the bills that are currently pending, I know one of the ones that I was asked to discuss was House Bill 357, aptly named. There, Metcalf proposed a bill that was, in essence, federal firearms nullification. Any law, federal law passed after January 1st, 2013 would be null and void here in the Commonwealth. While there are a number of other states that have passed similar bills, at this point in time, there have not been any federal challenges to whether or not those are constitutional. But given my experience, especially given the federal judiciary, you can pretty much expect that they will ignore the 10th Amendment and they will find that those bills are unconstitutional that were passed by the states, reserving their rights to define what constitutes the right to keep and bear arms that has not been otherwise limited to the U.S. Constitution. Unfortunately, as several of the speakers tonight mentioned, with Wolf in office, I cannot say that I see any pro-Second Amendment bills passing and being signed into law. Some of the bills, there are some questions as to whether there is enough votes for an override. At this point, it seems too early to tell. There are a number of very pro-Second Amendment bills that are pending in the House and Senate. And it's on us to get those passed. It's on us to let our elected representatives know how we feel. Let them know that we elected them. This is an issue that's important to me, and I want to see you move forward with this. Because if you tell me you're not willing to support it, then I have some decisions to make when it comes election time. We have the power of the vote. And unfortunately, too few individuals recognize the power of the right to vote. Everyone says my vote doesn't count. That's unfortunate. There was a constable race in Reading. Do you know how many votes the winner won by? One vote. One vote. One person hadn't come out that day, it would have been a tie vote. Two people didn't come out, would have went the other way. You still think your vote doesn't count? You need to remember that. And I realize that I'm talking on issues beyond just simply the Second Amendment, but these are so important. These go to the heart of the Second Amendment because we need to have our voice heard. One of the other topics they asked me to address is the pending litigation regarding a plethora of different municipalities that have violated state preemption. For those of you who don't know what that means, basically in our statutes, it states that no county or municipality may regulate in any manner the possession, transfer, carrying, and a number of other things of firearms and ammunition. Many different municipalities regulate it. They say, oh, you can't have guns in our borough buildings. You can't have guns in the park. You can't have guns here or there. I have litigated a number of those cases. The most recent case prior to a recent enactment by the General Assembly was in 2013 up in Erie, Pennsylvania. The case was Justin Dillon versus the city of Erie. There, Mr. Dillon had held a number of pro-Second Amendment rallies at the park. This time, he applied for a permit, as he always did, even though he didn't need it. And for whatever reason, the city solicitor said, well, we'll let you have your rally, but you can't have any guns there. He said, it's a pro-Second Amendment rally. Well, we have this ordinance from 1962 that says that there's to be no firearms in city parks. So he had contacted me, and thankfully through the help of the NRA, we were able to mount a defense. The ordinance at issue specifically said the individuals shall not possess a firearm. The statute, as I said before, says no municipality may regulate, among other things, the possession of a firearm. We went into the Court of Common Pleas and were heard by the president judge there on an emergency injunction motion. The judge would deny the emergency motion and would say that the ordinance did not violate the state preemption code. He would leave out key words to the ordinance that were found in the statute. That case would go up on appeal to the Commonwealth Court, where the Commonwealth Court would once again say, we have told you time and time again you may not regulate firearms or ammunition in any manner, and you continue to do it. Unfortunately for my client, because of the denial of the injunction, and because of the time frame it takes for the Commonwealth Court to hear a matter, he still held the rally. 8 individuals, including himself, were charged criminally with violating this ordinance. I represented them at the magisterial district judge level when the charges were filed. At that hearing, not one police officer could testify that any of these cited individuals actually had a firearm. They said we saw things that looked like firearms, slung over their shoulder or in a holster of that, but we never checked to see if they actually were. They couldn't tell if there was any serial numbers on any of the items. They couldn't tell anything about it. And in fact, even more telling, as the solicitor was representing the city in this matter, they didn't even submit a copy of the ordinance at issue. They didn't even meet their burden. They couldn't even establish that there was any violation. Yet, I bet everyone here knows what the outcome was. That judge found all 8 guilty of violating the ordinance. That would also result in an appeal, this time now up to the Common Pleas level. But the case was already at the Commonwealth Court in the civil context. The Common Pleas judge that heard the criminal matter said she was staying the matter because she had grave concerns over the statutory preemption and the fact that the Commonwealth Court was already hearing the civil aspects of the case. As I alluded to earlier, the Commonwealth Court would say, this is unlawful. You can't do this. We have cases back to the Pennsylvania Supreme Court in Commonwealth v. Ortiz, where the Pennsylvania Supreme Court said not only are you proscribed from being able to regulate firearms and ammunition under our statutory preemption code, you're also precluded under Article 1, Section 21 of the Pennsylvania Constitution. But that didn't stop those judges from prosecuting my clients. Thankfully, when the Commonwealth Court came down with that decision, the common pleas judge dismissed all the charges. It's a misdemeanor of the first degree for any municipality to violate that statutory preemption. We have a decision from the Commonwealth Court stating that the city had violated statutory preemption. How many of you here think that the district attorney brought charges against those city officials that were responsible for the charging and prosecution of my client? That's right, none. That's the problem with our system. This would happen again, but this time it was after what was called Act 192 was passed by the General Assembly. The General Assembly became aware of Mr. Dillon's plight up in Erie and said, we've had enough of this. We've already criminalized it. District attorneys won't prosecute it. What more can we do to make clear to you that you cannot regulate firearms and ammunition? So the General Assembly passes a provision providing for attorney's fees and costs. Oh yeah, that's an aspect I left out. My client who was prosecuted there, even after the Commonwealth Court came down and said it was unlawful, he had no right to get his attorney's fees and costs back. As I said, thankfully the NRA had stepped in. But other than that, he would have been out everything. So the General Assembly said, we had enough of this. They provided a number of provisions and changes, including what we'll call enhanced standing. So someone didn't need to be prosecuted in order to challenge the statute. That would later be challenged by certain individuals in the General Assembly. And the Commonwealth Court would say that that amendment that was passed unconstitutionally. Now that case has been appealed up to the Pennsylvania Supreme Court, and I believe briefs for the Commonwealth are due by the 28th of this month. Meanwhile, there were a whole bunch of municipalities that were violating these provisions. Before Act 192 went into effect, my office went and sent out over 200 letters to different municipalities that were violating the Act. And we said, look, this has been passed, you're going to have liability, we're not looking for you to simply pass it on to your taxpayers. All we're asking is that you repeal your illegal ordinances. I would say approximately 80% of them ended up doing that once they got our letters in that. There was a number of other ones that didn't. One of those was the city of Harrisburg. Yeah. There's a wonder. And there were issues there. There was another law firm in the Harrisburg area that was quite clear. Actually, in their announcement that they were filing an action, said they just needed to be the first to file. And in being the first to file, they failed to bring a number of counts. They didn't bring arguments under Article 1, Section 21. They didn't bring arguments under the Second Amendment. They just wanted to get their payday under Act 192 and never saw, even though there was already a challenge pending to the constitutionality, that it would be ruled unconstitutional. We would also file an action shortly thereafter to make sure that all the issues were preserved. Our case, because we included Second Amendment issues, was later removed to the federal court, where the federal court has now sat on that case for 10 months, doing nothing. The state case proceeded forward with that other law firm, and a preliminary injunction was issued in relation to several of the ordinances. So that seems good. The city appeals. And during the appeal process, it becomes known that the Commonwealth Court ruled that Act 192 is unconstitutional. Their payday just left. And I saw the writing on the wall.